Hello, everyone, and thank you so much for being here today and sticking with us both virtually and in person. And we're continuing on to panel 2. My name is Leah Fowler, and I am faculty at the University of Houston Law Center, and I will be your moderator today. So during panel 1, we learned a lot about the social determinants of health. In fact, you might recall from Dr. Buck's slides that things that we don't always associate with health can have a huge impact on health outcomes, things like social and economic conditions and the physical environment. In panel 2, we're going to build on what we just learned and see if there is a similar story in law. We'll look at what research says about whether legal and policy conditions or unmet legal needs can contribute to inequality, and if diversity in the legal workforce can help mitigate disparities in law and increase trust in the legal system. We will focus specifically on energy justice, land use and real estate, criminal justice, and representation. I am delighted to introduce our esteemed panel. We have Gina Warren, Professor of Law, A.L. O'Quinn Chair in Environmental Studies, and Co-Director of the Environment, Energy, and Natural Resources Center at the University of Houston Law Center. Kellen Zale, Associate Professor of Law and George Butler Research Professor at the University of Houston Law Center. And Sandra Guerra Thompson, Professor of Law, Newell H. Blakely Chair at UH Law, and last but not least, Verna Williams, the CEO of Equal Justice Works. We will hear from all four, and then we will open the panel to questions and discussion from the audience. And with that, I turn the mic over to Professor Warren.
Well, good morning, everyone. I hope you're doing well. Thank you so much for coming, and I know that we have a ton of people online, so I'm just thrilled and honored to be here. So I'm a little intimidated, I have to say, to be presenting at the medical center. I can tell you I was a pre-med before I decided to go to law school, and I can tell you a little story really quickly of why I didn't go to medical school. So I was a science major, psychology, and thought that that's what I wanted to do, and I volunteered at a hospital, and then I decided I couldn't handle people in pain. I got queasy. So even if it was literally like just drawing blood, but they were screaming and they were upset, that it made me literally sick to my stomach. And so I either would have to be like a forensic scientist of some sort, which was not cool at the time. Now maybe that would have been awesome. But I decided to go in to be a attorney, because before I had gone to undergrad, I had been a paralegal. So I am a first-generation high school grad in my family. I went to community college, I was a paralegal, and then I decided to go to college and never took an entrance exam to get into college because it wasn't required. If you performed well at the community college, you could just go straight into undergrad at the University of Arizona. And so that's my path. So my path is really crazy. And then I got out, and then I decided to be a paralegal for a little bit longer because I wasn't ready to go to law school yet. And then I decided to go to law school later. So, so don't let this fool you. I'm really, really old at this point, and that was a long time ago. But I am so thrilled to be here. And so I'm talking to you today about environmental justice and energy justice, and this need to diversify in these areas. And so, let me see if I don't mess this up. So this is what I have for you today. I have environmental justice, what is it? Just for a minute. I want to look at Houston as a case study, talk about briefly the lack of diversity in the energy industry, and then what the benefits are of diversification. So environmental justice recognizes that marginalized communities and communities of color, low-income communities, have historically been overburdened by energy and environmental infrastructure that's polluting. So it's either leaking, it's polluting, it's in the air, it's in the water, it's in the ground, whatever it is. And there's recognition under the law that we shouldn't do that we have federal protections that prevent marginalized communities from being overburdened by things that we all need, like railroads and waste management facilities and highway systems and power plant facilities, those types of things. And so But just as a little bit of a statistic for you, I have a lot of them. Hopefully I can get them right. But you have Black people in the United States are exposed to 21% more pollution, even though they produce 23% less. Okay? And then you have low-income families and families of color that are paying upwards of 30% of their income to energy-related costs, whether that's heating their homes, cooling their homes, transportation, gas, those types of things. And so there's an obvious disproportionality in the United States, and that in part is due to the environmental hazards that I want to talk about. And so the types of environmental hazards that I generally look at are, you have air, in that, so you have air, water, and land pollution due to, you have cement and chemical plants, refineries, wellheads, power plants, that's electricity, so for electricity purposes, refineries for transportation for gasoline type of things. You have landfills, toxic and waste dumps, highways, railroads, and exposures to leaks and problems with all of those things. So in addition to these polluting factors, these polluting industries, you also have situations where the communities that we'll talk about are also disadvantaged by not having benefits of green space and not having benefits of more parks and more trees and these types of things that will lower the energy required to supply what they need for living. And so Houston, as an example, is definitely an example. And so this was actually alluded to earlier by Dean Spann. And so I want to talk about this a little bit more. It's almost like we were in collusion, but we weren't. But so the Houston Mayor's Office designated certain areas as what were called complete communities. And these complete communities are designated on this map. And one of them is the 3rd Ward, that's where we are right now. And so these are areas that are environmental justice communities in Houston. And so keep in mind of where this is, and also for our purposes, keep in mind of where it's not. Okay, so as we progress, as we look at the next maps, we'll think about where it's not. And so they had done that report in 2017, and then the Air Alliance Houston did another report on top of it to look at the environmental issues within those communities. And so this is what they were doing. And so they took toxic release inventory that the Environmental Protection Agency has of all the different types of toxic pollution facilities. And they mapped them. And they mapped them on the Houston, the designated areas. And you can see that this is the light color is the low income color. And then you have people of color is the medium color there. And then both is the darkest. And so you can see in the areas that have low income and people of color, that's where you're seeing all of these polluting facilities. And so the number of polluting facilities, you have about 850,000 people in Houston that are living in one of these communities within a mile or within that area, so within their community itself, or within a mile. They have 1,300 of these polluting facilities. And so the consequences of that are great. And so this was some of that came up earlier. So there's land consequences and those types of things that I think my colleague is going to talk about more. But we also have these health consequences that are from the pollution itself, from the damage itself. So you have asthma. Let me read these to you. I should have put the map up there for you, or the chart. But adult asthma, 9.6% higher in these communities in Houston. Coronary heart disease, 16.1% higher in these communities. Chronic obstructive pulmonary disease, 18.3% higher. Poor physical health, 22.5% higher. Poor mental health, 17.7% higher. And people with no insurance, 25.2% higher. in these communities that are outlined on the map that I was showing you. And so this is something that I think he actually literally quoted this earlier when he was giving the presentation with the introduction, is that where we live matters, right? It's important. It's important with who we're going to see the doctor, who we're going to school with, who we're associating with, what opportunities are there, what banks are there, whatever is there. And when you have these communities, it's showing that the people who are living in them are suffering, and they're dying 23 point, this is the actual statistic that came up, 23 and a half years discrepancy in Houston between these communities. So you have an average age, I don't know if I wrote it down, 89.1 versus 65 something. But you can see the areas in the blue, those are our more expensive areas to live. Those areas, people are living longer. In the areas that have been designated as as environmental justice communities, they're not. And the discrepancy is, in fact, they found in this report, 23 and a half years. So quite significant. And so, what I'm thinking about this, I'm thinking about it from an energy perspective. There's a lot of pollution out there that's happening from other industries, like cement industries and chemical plants and things like that. But when I think about this from an energy perspective, I went and looked at the numbers. So I'm like, well, clearly there's some bad decisions being made here, and a lack of community involvement and a lack of fair treatment, which is not supposed to happen under the law. And so when I looked, there is 72% of our senior executives in power and utilities industry are white men. And so this is globally the case. And so I don't need to tell you what the other numbers are, because you can figure out that they're not very high, no matter who else you're putting else in there. And so 72% of senior executives, so the decision makers for the energy industry, are white males. And so I looked, the US Department of Energy had a study that was done about the US sector to see what the workforce looked like. And so they have 25% were women, but the problem is those women were not in roles of leadership. And so they were there, so 25%. You had 16% Latinx and 8% Black, and the numbers were worse in extractive industries like oil and gas type of industries than in renewable energy sectors, so the more progressive sectors. And so these are some, see if you can see those, hopefully those show up, but those show you the difference between of who is actually in the energy workforce in the United States. And so the blue is the energy workforce, the yellow is the national average. And so you can see that any type of minority type of individual is less than the average, than the national average in energy. With the exception of union workers are higher and veterans are higher. But that's the only two groups. So this is something that I've asked my research assistant to help me with. We're trying to understand what I can offer in this area. And so we've been looking at, and this McKinsey report was cited earlier, so looking at questions of whether a more diverse leadership in policymaking decisions can result in better ultimate outcomes for everybody. And the answer seems to be yes. We see that, according to this, that you have higher ethical scores, more positive environmental impacts, and higher climate strategy scores for more diverse working groups and decision makers. What is interesting to me is it doesn't mean they get along, right? So it doesn't mean that everybody's happy with each other or even likes each other. but they seem to make better decisions. And I think about this, I was talking to my son on the way to school this morning, I was thinking, it's like the echo chamber. It's like you got this buddy, and you're like, yeah, I think we should go take over the school today. And your buddy's like, yeah, let's do it, right? Because it's an echo chamber. And of course your buddy who loves you is gonna be like, yeah, I'm the same as you, let's go do that. Where if you had somebody else in the conversation was like, that might not be a good idea, then maybe you're going to make better decisions, even though they're not your best buddy. You don't have to get along with them necessarily for that reason, but you're making more robust and better decisions by having some other voice that might be like, I don't think that's a good idea. And so we know that diverse teams make superior decisions. You get new perspectives. You get a raise in your critical thinking. So you're challenged. You have somebody sitting there that might not have the same background as you. And they might be just telling you, I don't think that's right, what you're saying. I think this is a better way. Or maybe, just maybe, we should go talk to the people who are getting the most impact. So maybe we should go talk to them and see what they have to offer and bring that meaningful involvement back to the conversation. And so that's what I have for you. I want to thank a lot my research assistant who really helped me with this. So Frank Chambers for his invaluable help in all of the research that he's been doing for me. So thank you.
All right, I'm going to stay seated because I do not have PowerPoints and I have a laptop that won't fit up there. My name is Kellen Zale. I'm a professor of law at the University of Houston, and I teach, as our moderator mentioned, I teach property, land use, real estate, local government law. And so I am not an expert in health law, and I'm definitely not a doctor, not even pre-med ever at any point. So you might be like, what are you doing up here? But I think as the first panel touched on, there are connections, and the phrase, housing is healthcare is something that people are very aware of, I think, in the medical field, maybe less so in the legal field. And so in my 12 minutes or so here, I'm going to kind of try to touch on 4 points and kind of get through these. So because in the context of real estate and land use law, the historical context matters, as you kind of heard from your first panel today, I'm going to briefly touch on that long tail of the historical de jure discrimination and how that is still in play, even though it's all illegal now for the most part, that it still has set up an uneven playing field where our currently facially neutral laws in real estate and land use operate. They're neutral, but they don't have neutral impacts. And then I'll shift to the second point, which is kind of just touch on a few of the current, seemingly neutral current laws in real estate and land use that do produce racial disparities, and there's other forms of disparities. There's disparities with regard to immigration status, sex, gender, disability, all sorts of other ones. I'm going to focus mostly on racial disparities and ethnicity disparities because that's what the research is on, and that's what the task of this panel is on. But being mindful that there are others in these areas of law. And then third, I will kind of touch on, but again, Gina already touched on, in the morning panel already touched on, which is, this link between disparities in real estate and land use and health outcomes. And then last, I'll try to end on a positive note. I'm not going to directly speak to the impacts of diversity in legal workforce and legal education or the medical workforce because that's not my area of expertise, but I'm going to end with some positive notes about changes we are seeing in some of the areas that I will have spoken about, and hopefully in the Q&A and with other speakers it might come out how those changes may relate to the fact we do have more people who are different serving on community boards like zoning boards, more lawyers who are from different backgrounds, advocating for laws at the state legislature and those types of things. So those are the 4 points I'll try to get through here. So the historical context, I think I can be brief because it was spoken about earlier, and many of you are just well aware of this. But Today, de jure, meaning by law, discrimination and segregation in real estate and land use laws is illegal, and it has been for decades. But it was legal for a very, very long time. And it's everything from explicitly racial zoning was legal up to right up around 1920, where literally instead of like an R1 zone that was like one-story houses, R2, two-story houses, it was R1, whites only, R2, ethnic group only, R3, ethnic group, other ethnic group only. So that's been illegal since 1917, a Supreme Court case, but it was legal for decades before that. And that set up the built environment in many communities in a way that those patterns kind of have persisted because property and the built environment has a long tail. It exists for a long time. In addition to kind of that area of illegality, there was redlining, which we've already spoken about, which until the 1950s, 60s or so was legal, meaning the government backed loans, mortgages in quote unquote good neighborhoods that were majority white, but they weren't offering that government backing of financing in the quote unquote bad neighborhoods, meaning like the individuals who could afford the homes or wanted the homes in those neighborhoods, like they couldn't get loans because the banks were like, well, we're not backed by the federal government here. And that was legal again until the 1950s, 60s. The government also, until the late 1940s, explicitly permitted private contractual arrangements like you would see in deed covenants that restricted who could own or rent houses. And again, those were private arrangements, but courts upheld them until the late 1940s. And so again, setting up who could live or own properties, yes, it's been illegal for decades and decades at this point, but like those historical patterns kind of were put in place for so long that like the long tail has persisted. And so you can see in current statistics, and I don't have PowerPoints, I should, because I do have a bunch of statistics, but I'll try to be clear about them. You can see in current statistics how this long tail has manifested in current disparities. So in terms of the homeownership gap, it is a 30% percentage gap. 70% of white households are homeowners. It's right around 40% for black households. And that's actually the gap itself has gotten slightly larger over the last 50 years. It was around 27% in the 1960s. It's at almost 30% now. And there is a similar gap with other races and ethnicities. It's not quite as big, but the white homeownership rate is higher than almost every other ethnicity group. There's the home value gap, which is, okay, when a family of color is, or an individual of color is a homeowner, the value of their house is 1/2 to 2/3 less than the value of a comparable home owned by a white household. And again, this has to do with like the comparability is in terms of like the quality of the house, the number of bedrooms, the plumbing, the central air conditioning, but the neighborhoods they're located in are different, and that plays into the valuation difference. Mortgage qualification gap in terms of financing. So again, it's illegal for lenders to discriminate in terms of race or ethnicity, but people of color who have the same financial statistics, we're not even talking about like the background disparities, why people of color might have like less credit overall, but even if they have the exact same financial statistics, there are studies showing that they get approved at lower rates, or they get approved for mortgages at higher interest rates than comparable white applicants with the same financial statistics. In terms of rentership and renters, tenants, people of color are disproportionately renters, and renters have 1/89th the wealth of homeowners. And so that statistic, and again, it's because of the house as being like, even if you have a maybe not $1 million house, a medium moderate house, like that is a huge asset, and it gets counted towards your wealth. And so because, again, that factor plays, that 1/89th plays into any type of renter, whatever race they are, white, Asian, black. But because people of color are disproportionately renters, because again of the historical legacy and the kind of the long tail of history, that, huge gap in, wealth, particularly affects them. And in terms of kind of, because renters are, there's renters who are renting luxury condos, there's renters who are renting moderate, income housing, there's renters at the lowest income scale that are getting public assistance, and people of color are overrepresented in the lower income rental groups as opposed to like the higher income rental groups compared to their population in the general population. And I can't even get into all of the data about homelessness, but just one data point is homelessness is tied into housing as well, and real estate. It's tied into a lot of other things as well, but it's linked here. Just with regard to one group, Black individuals make up 13% of the general population, but 40% of the homeless population, and there's disparities with Native American and Pacific Islanders as well in there. So kind of turning, with my very few minutes left, to my last 3 points. Turning to my last 3 points, what are some of the current seemingly neutral laws that perpetuate these historical disparities and long tail of kind of the de jure segregation and discrimination, which we don't have anymore? And so some of them are things like that you probably heard about, things like exclusionary zoning. And that's just things that seem on their face neutral, like, a minimum lot size or density restrictions, only single family homes, no multifamily, those types of things, which have valid reasons for existing. Like those were all passed for safety reasons, for aesthetic reasons. You want to make sure fire trucks can get in between buildings, people have light in their apartments. But over the decades, those have been kind of used as a way to constrain what can get built and constrain it along economic lines, which then translates into a lack of housing choice, and those neighborhoods don't have other forms of housing. So if you are somebody that can't afford a single-family home on a half-acre lot, there is no way you can reside in that neighborhood of opportunity. It's illegal to build anything else. The developer who wants to build there and is like, the market's asking for me to build there, cannot build there. They have to go through they can try to go through land use approval processes, but they generally are going to get pushed back, and you've heard about NIMBYism and pushed back and not approved. Property taxes. I mentioned that property tax appraisal system is in theory neutral, like all residential property is taxed at 2% of its appraised value, like is in a typical type of property tax appraisal system. However, there's data showing that lower value homes are systematically given a higher appraised value, and higher value homes are systematically given a significantly lower appraised value, meaning like that $1 million house isn't appraised at $1 million, it's appraised at maybe $600,000. But that $100,000 house is like either appraised at the full $100,000 or maybe even slightly above. So they're both appraised at 1%, and that higher homeowner is still going to have a numerically higher tax bill, but they are getting a discount overall. Their effective tax rate is less, and the community who owns lower value homes, which again is often going to be correlated with people of color, is effectively bearing up more than their fair share of the tax burden for property taxes. There's a whole series of laws related to landlord-tenant, and I don't really have time to get into these, but some of the laws that affect tenants, who again are disproportionately people of color, aren't even directly landlord-tenant laws. It's how our legal system has set up preferences for home ownership, which again is going to tend to benefit those who can afford home ownership, which is going to be more likely to be white people, wealthier people, and disadvantaged tenants. And so you can think of just in terms of stability of housing. Like, we have made laws and policy choices to make the 30-year fixed rate mortgage widely available. Like, again, there was a history of it not being as widely available. There's still issues with it. But if you can afford home ownership, you can get this, and you have like a 30-year window of like a lot of predictability with your housing costs. Yes, you might have repairs. Yes, your property taxes might change year over year, but you have like that, a big chunk of your housing cost is predictable, and you kind of have that housing stability. Renters in most jurisdictions have nothing like that. Most jurisdictions do not allow rent control, rent stabilization, and most jurisdictions allow landlords to evict for any reason. And so renters can lose their housing essentially with 30 days notice, or have a massive increase in their housing costs with 30 days notice in most jurisdictions. And again, that's a choice of law and policy that we've kind of, you might not think to like analogize mortgages to like rent control laws, but like they both affect housing stability. So there's more I could go through, but I'll rush through my third and fourth point kind of quickly. So other folks have already talked about this issue of like housing is healthcare, and the disparities that Gina listed on her slide. I have more statistics, but I'll just kind of skip over those. Like, where people live matters. There's data showing all the things she talked about, and the others have talked about asthma, from asthma to cardiovascular disease to chronic stress to all those implications. So to kind of rush over that point and end on my hopefully positive note is, in conclusion, there are signs of that, and again, hopefully in the discussion maybe we can flesh out where these signs of change are coming from, but there's signs of change. So with regard to some of the things I spoke about as kind of seemingly facially neutral laws that have disparate impacts, things like, exclusionary zoning. You've probably seen in the news, and so Houston's famous, we don't have zoning, but most cities do. But a number of cities and large cities have, over the last 3 to 4 or 5 years, made significant efforts with zoning reform, either abolishing single-family zoning or making it at least as of right to build a duplex. Like if you can build a single, and like that might seem small, like, okay, because not everybody's going to tear down their single-family home and build a duplex tomorrow, and that will only add some number of units to the housing market, but it adds some housing choice. And some communities have gone farther. And some states are doing this at the state level. So California is doing this at the state level, even if local governments don't necessarily want them to do it. You have, with property tax appraisal, you have reforms being made with regard to property tax appraisal. And in terms of, there's an education component for appraisers to like realize that this disparity exists, and it's in many ways partially implicit bias, and appraisers are professionals, they're not necessarily lawyers, but training to realize that. But there's also kind of bigger picture proposals to recognize that, okay, because we rely on property taxes for so much, and it turns out it's kind of a more regressive system than we've been thinking it is, maybe the state and federal government need to provide more tax funding, and we just like slot out some of that property tax support for things like schools and roads and substitute it in with flat grants from the federal or state level. And with things like, the renters and some of the disparities they have due to their lack of stable housing, we have seen more states pass things like good cause eviction, which means the landlord has to have a reason. Like if the tenant's breaking things, the landlord can evict them, but the landlord can't just say, oh, I want to rent this for twice as much to somebody, so I'm going to send them 30 days notice. More communities are also thinking about rent stabilization, maybe not quite rent control, but some level of rent stabilization, and so that's a little bit getting on the radar. It was like, absolutely not something any community want to talk about because economists say it's terrible, but there's some realization that there's some benefits and maybe it's worth the trade-offs. And there's other reforms I could speak to. So I will end there because I've gone a minute over, but thank y'all for having me.
Good morning. In the spirit of the day, I guess I should introduce myself like Gina did by mentioning that I'm a proud product of the public schools in Laredo, Texas, one of the poorest counties in the state. And I could add the first Latina law professor in the state of Texas. Which, shouldn't that have happened like in 1925 or something, at least? And that's a
Latina chair.
Oh, and okay, my dean, he's worse than my mother. Thank you, Dean Baines. Yes, the first chaired professor in Latina chaired professor in the state as well, which is another really terrible sign of. So I'm here today to talk about work that comes out of my community work that started with my research in wrongful convictions and led me to do some work at the state level on wrongful convictions. And then in 2012, the Houston mayor, Anise Parker, appointed me, as well as my friend Nicole Caceres, who would become a longtime co-author with me, to the board of directors of the Houston Forensic Science Center, which was created to remove the crime lab from the Houston Police Department when it was discovered that this lab was completely dysfunctional and had led to several wrongful convictions of Houstonians like George Rodriguez, who spent over 16 years in prison for aggravated rape, and it really just completely derailed his whole life. After his lawsuit, Mayor Parker publicly apologized to him, and it was a really very difficult time in the early 2000s with that lab. So in 2012, this board was created, and we oversaw the management of the forensic lab, and I was on the board for 7 years, along with Nicole, who she became the chair, and I became ultimately the vice chair. And the transformation we saw was incredible because we put scientists in charge of the laboratory, not a police chief, and we insisted on good science and on correcting the errors that they had, that the lab had committed in the past. And much of that turned on a kind of pro-prosecution, pro-police bias. And so fast forward in 2020, after doing years of research and study about bias in a clinical laboratory setting, in May 25th of 2020, police officers in Minnesota killed Houstonian George Floyd. And that set off a summer of protests and charges of systemic racism that we needed to confront, and some counter-narrative about blue lives also mattering, and it became a very polarized discussion. And so Nicole and I set out to try to bring some of the lessons of science and the ways that scientists think about bias and addressing it, and looking at ways to incorporate some of those techniques, these interventions, into the criminal justice field. And one of the things that we learned early on was that the medical field was actually far ahead of us in terms of thinking about these things and trying to incorporate these interventions. So we could start by I'll start by just saying we are all biased. It's an undeniable proposition that human beings have a tendency to be influenced in their mental processes by a number of different kinds of bias. And if we accept that as a base proposition, then we can realize that as a result of that, we tend to make erroneous decisions. And we can say, okay, well, knowing that, then what are some of the things that we can do to improve the way that we make decisions? So, again, if we start from the proposition that all people of all races and ethnicities are endowed with similar innate traits and talents, then we should expect in a just society to find that people of all races and ethnicities will have similar outcomes in terms of their rates of law-abidingness versus wrongdoing, health versus illness, wealth versus poverty. But as we've discussed today, and considering the kind of racial history that we've had in this country, going back to, of course, slavery and Jim Crow laws, and into the society in which we live today, we see, understandably, that at all of these levels we have enormous disparities. So the question, as I approached it, was how best do we move forward in a productive way in thinking about changing the status quo? So just to talk about a couple of disparities that have not been addressed today, some of the research we did had to do with the medical field. And there were a lot of studies about doctors and their practices in prescribing pain treatment. And if you think about pain treatment, it's doctors trying to alleviate a patient's symptoms, right, their pain. Well, one meta-analysis on emergency department use of pain treatments found that Black patients were 36 to 40% less likely to receive any analgesia compared to white patients, and only slightly lower disparities in the receipt of opioids for acute pain. And Hispanic patients were 25 to 30% less likely than white patients to receive these treatments. The disparities have even been more pronounced when you talk about patients who are both Black and female. So in one study that was, at least to me, quite shocking, Black women die from pregnancy-related complications at 3 to 4 times the rate of white women. And you might think, oh, well, that has something to do with socioeconomic factors or drug use or smoking, obesity. But actually, when we control for all of those factors, this was the disparity, right? So none of those factors explain this disparity. And this led Dr. Neil Shah of the Harvard Medical School to say, the studies suggest that we, the physicians, believe Black women less when they express symptoms, and we tend to undervalue their pain. In the criminal justice setting, with regard to prosecutorial charging, again, thinking about what the professional in that role is doing, they're seeking to get justice, oftentimes for victims. And so what the studies show is that charging practices vary greatly depending on the race of the victim. So 6 studies that focused on victims' race and ethnicity for initial screening, and in 5 of those, they discovered that cases with minority victims result in punishments that are more lenient, whereas only 1 study showed no differences. In the cases of murder, the studies are also pretty striking. So compared to other racial combinations, murder cases involving Black defendants and white victims were 143% more likely to be charged with first-degree murder, and they were also more likely, twice more likely to be tried as capital murder. So whether we're talking about relieving a person's pain or assessing the harm caused, we're talking about very subjective assessments. Doctors and prosecutors, and for that matter, really all participants in these fields, exercise wide discretion, and they base their decisions on numerous subjective factors. So for doctors and prosecutors, the information they receive can influence how they view a patient or a case. Patients and victims will express themselves in different ways, and others in the system may also describe situations that they receive in stereotypic way. So I just want to talk a little bit about some of these biases. When you have patients or victims who view professionals as treating them in stereotypic ways, they can experience something called stereotype threat, which is a stressful psychological state that occurs when a person fears being judged. And there's been a lot of discussion today about this kind of mistrust. And the medical literature also speaks about interviewer bias that can affect the answers being given based on how questions are phrased. But I want to make this point. Whether we're talking about the proper prescribing of medication or the proper charging of a crime, the problem isn't necessarily that people aren't getting enough or that charges are too much. Not necessarily, but what we do know is that disparities exist where there shouldn't be. Where there should be equality, there isn't. And so how do we address that? Well, I think about this in terms of remedial interventions that can be used to reduce the bias that affects all of us. And I take these lessons as what in a laboratory they would think of in terms of quality control for the process. So rather than thinking about moral judgments, about negative feelings that people may have or what have you, we can think more clinically about eliminating bias and some of the techniques used for doing that. So I want to talk about a 2021 study that was done by the National Council on State Courts for the criminal justice field that speaks about the research in this area. And one in particular is about how people think, how they think about their patients or their victims or defendants. And in the interest of time, I'm going to skip over a couple of things, but the study speaks about an intervention known as intergroup contact, which involves having people of different groups engaging in activities, working together towards a common goal, with members having equal status, where they can get to know each other on an individual basis, and where that group activity receives institutional support. which sounds to me like a diverse workforce or a diverse school setting that would reinforce this kind of intergroup contact. In criminal law, for example, within District Attorney's Office, this finding would suggest that having diverse teams making decisions within the organization will reduce the effects of this kind of implicit bias that we see reflected in the studies. And again, the point here is that this kind of intergroup contact intervention has been shown to be quite effective in improving the decision-making practices of the group, of improving the institution overall, improving the thinking of all members in the group. And it sort of goes back to the intersectionality that Dr. Buck was talking about, right? That we are not as people just one factor, like I am a woman, that's all I am, that we all represent many different kinds of backgrounds and characteristics. So I just want to, I'll leave it there, but there are other interventions I could talk about in the Q&A, but thank you so much for having me today.
All right, well, good morning, everybody. I'm Verna Williams. I'm the CEO of Equal Justice Works, and I'm just really grateful to have been invited to participate in today's conversation. This is a really important conversation. I also want to thank the organizers of this conference, particularly April Moreno and Jessica Manto, for all the work that they've done and all their assistance, and Frank Chambers, who did some research for me to help me prepare for today. Yeah, Frank Chambers is getting a lot of shout out, getting a lot of love today. So I have the privilege of leading the nation's largest facilitator of public interest fellowships. We know and operate from the principle that representation matters. And in my 10 minutes or so, I'm going to talk about two important dimensions of representation that are at risk with Students for Fair Admissions, or SFFA. First, of course, racial and ethnic diversity. That's what's brought us here together on this April morning. And secondly, in terms of the staggering failure of our system to ensure that people have someone on their side when they are confronting civil legal matters. So turning first to racial and ethnic diversity. Texas is the perfect place to have this discussion for lots of reasons. But because one of the cases leading to Brown versus Board of Education happened right here, Sweat versus Painter. The plaintiff in that case, Heman Sweat, was a Houstonian. That's why I raised him today. He was inspired to act by advocating for voting rights, that was pre the Voting Rights Act, and for post office employees. He applied to University of Texas, which rejected him on account of his race. The state hastily created a law school for African Americans in the course of the litigation, but the United States Supreme Court found that the Equal Protection Clause required Mr. Sweat to be admitted to the University of Texas. Now, because the alternative was in no way equal. This was one important step toward destroying Jim Crow's reign in this nation. It would take, of course, the United States Supreme Court's ultimate ruling in Brown versus Board of Education and upholding law school and graduate school affirmative steps to make legal education possible for me and for many people in this room. And yet, despite those efforts and those advances, the legal profession does not reflect the diversity of this nation. About 80% of the attorneys in this country are white, compared to about 60% of the national population. We know that representation matters. If we can see it, we can believe it and achieve it, the saying goes. Martin Luther King Jr. knew that. He called himself the notorious litigant. So before the notorious RBG, the notorious BIG, there was the notorious litigant. And he said that about himself because he used lawyers a lot. Over the course of his career, which from the time of the Montgomery bus boycott, when he was only 26 years old, until his assassination at the age of 39, only 13 years, Dr. King hired 70 attorneys. Even more remarkable, over half of the lawyers were Black. And this was at a time when African Americans were barely 1% of the legal profession. Having Black attorneys in the courtroom where there were white juries, white judges, white court personnel, that sent a strong message. It countered stereotypes about African Americans. Unjust laws were part and parcel of the system, as you've gotten a hint of today already. But Dr. King believed that change was possible, especially with Black lawyers doing the work. And so today, after almost 50 years of affirmative action, people of color are just 21% of the legal profession. When I started preparing for today, I wondered about the impact of diverse representation on clients. I had some awareness of that data or literature in the context of the medical profession. Surely there was research about the legal profession. But in this, as in many other areas, the legal profession is way behind the medical profession, way behind. Very meager data. And that which exists examines just the criminal setting. A 2021 Boston study found that Black, poor, and working class defendants mistrusted court-appointed attorneys in large part because most court-appointed attorneys were middle class and white. On the civil side, we are woefully behind at looking at ourselves and making change. And so that leads me to the second dimension of representation, actually having someone to advocate for you in the face of an eviction, losing custody of your children, or digging out after a disaster. The sad reality is that for far too many people, no help exists. The Legal Services Corporation reports that for low-income people, 92% of their legal needs go unmet. 92%. And when you consider the people who are not low income, that is, people who earn too much to qualify for legal aid, but not enough to afford their own attorneys, Arizona State University professor Rebecca Sandra tells us that as many as 120 million legal problems go unresolved every year. 120 million. In many instances, people may not even recognize that they have a legal problem. They think it's just bad luck that a hurricane wiped out their home, and FEMA's regulations are so Byzantine they can't figure out what to do next. That a health problem has led to bankruptcy and collection agencies coming to their door. That their employer is stealing their wages. It's just bad luck. And these folks try as they might to handle their problems on their own. The number of lawyers focusing on populations with great needs is very small. According to the American Bar Association, fewer than 1% of lawyers are paid legal aid attorneys. Fewer than 1%. This lack of representation in both dimensions represents two distinct but related problems that add up to the same overarching issue: a justice system that doesn't engender trust in the people it purports to serve, jeopardizing the rule of law and even democracy. And it may sound hyperbolic, but when you think about it, this is a time when public respect for institutions such as the United States Supreme Court has reached historic lows. Lack of representation in both senses is a critical problem that requires an all-hands-on-deck response. These civil justice matters are all the more dire when one recognizes them as manifestations of systemic oppression. And Kellen gave really compelling evidence of how the law has helped to get us in the situation that we're in. I see the law as actually playing a starring role in producing this racial hierarchy. I picked housing. Everybody's talking about housing because, I mean, it makes sense. Communities across this nation are racially identifiable thanks in large part to policies such as redlining, which we've heard a bit about. The federal government itself pioneered this practice. That's the federal government. in the 1930s, allowing lenders to discriminate in financing home ownership because of buyer's race or ethnicity, and they did so until the 1960s. And as a result, housing segregation is prevalent across this country, resulting in, as we've heard already, the vast and growing disparities in wealth, education, health, among other things. Low income and communities of color are more susceptible to the effects of climate change because of these disparities, suffering more when disaster strikes. And so our strategy as an organization has been to develop and deploy public interest leaders. Our fellows are on the front lines of dealing with many of these issues. And just to give you an example of some rays of hope, Equal Justice Works fellow Morgan Colonna wrote about her experience navigating unlawful evictions in Richmond, Virginia. And that's a city that bears the notorious honor of being the second highest eviction rate, having the second highest eviction rate in the country, Richmond. Morgan has a project that's focusing on Richmond's East End. That is where low-income and Black communities are concentrated. And the one reason they're concentrated there is because the federal government decided to construct I-95, the nation's longest north-south interstate highway, directly through the heart of the Black community. So relegated to the East End, low-income families residing there today confront substandard housing, higher rates of poverty, and fewer resources for health promotion than other neighborhoods in the city. Recognizing the link between safe and stable housing, as we've heard today, Morgan created a medical legal partnership at Virginia Commonwealth University in Richmond. Doctors, nurses, and social workers screen patients for potential legal issues, and they refer those issues to Morgan just as if she were some other subspecialist. And from there, Morgan helps those patients resolve legal issues which have a direct impact on their health. Because of fellows like Morgan, minoritized communities have a voice. Representation matters. The disastrous proportion of the access to justice crisis and the changed landscape in higher ed admissions require us all to think creatively. At Equal Justice Works, we are exploring developing new pathway programs to encourage and support BIPOC young people to go to law school so they can serve their communities. With this program, we hope to tackle both dimensions of representation. And to that end, I am looking forward to today's panel on pipeline programs. We also recognize that the access to justice crisis is so vast that even if every single lawyer in this country did pro bono work, there would still be unmet needs. That means we need other professionals other than lawyers to step up. Now, this is the medical profession came to that conclusion a long time ago, and you all have been talking about the healthcare workforce. We need to develop a legal care workforce, if you will. A few states, Arizona, Alaska, Delaware, Montana, and South Carolina, have made it possible for certain trained paraprofessionals to help. We're just at the very beginning stages. But for us as an organization, we are considering developing programs for what's been called community justice workers, trained paraprofessionals to provide much needed assistance. These aspects of our strategic vision target the lack of representation in both senses, ensuring that families in Richmond, for example, don't have to confront eviction alone, and making room for more folks of color to serve their communities. Representation is vital to reconstructing a legal system that works, irrespective of race, gender, immigration, or socioeconomic status. It's vital to realizing the promises of equal protection and equal justice. Representation in both dimensions is critical to our democracy. As we regroup in this post-SFFA world, let us draw strength from the many people who came before us, who made it possible for us to attend law school and medical school. And as I close, I'm returning to where I started with Mr. Heman Sweat. When UT turned him down, Mr. Sweat could have abandoned his dream. He could have left Texas to attend some other law school, or he could forge ahead in the face of a legal system that had long protected racial hierarchy. We knew which path he chose. Let us forge ahead toward making equal justice under law a reality. Thank you.
Thank you so much to all of our panelists. That was wonderful. I'm really appreciative. I'll take moderator's privilege and ask the first question. If those of you would like to ask questions from the audience, if you're in person, please, queue at the microphone, and anyone who's participating online, please ask them via the Q&A. So my question for the group is that there seems to be a theme that the medical profession is ahead of us in a lot of ways. And one of the ways that I think is really interesting and relevant, not only to the theme of this conference, but also other questions we've received, is that we seem to lack sort of the empirical base that maybe medicine has already either started to build or in some places established. So my question for the group is, what lessons do we think we can learn from medicine? And specifically, what ways do we think we can incentivize the growth of that evidence base that we need to make really informed policy on the law side?
Go ahead.
Well, I was thinking what lessons we can learn. I think we need to have humility. We need to be able to look at ourselves. I think that the medical profession has been able to do. Perhaps there's a distinction between the professions themselves, and that medicine is a field in which research and empirical research is really part of the discipline, whereas the law is a profession that's looking backwards and relies heavily upon precedent. And so as a result, lawyers tend to be much more conservative. They're always looking at what we've done because what we've done is the best indication of how we should move forward. And so I think in part, I mentioned humility, but I think it's also just breaking apart, recognizing that the past doesn't necessarily have to be prologue, and that we need to, and I think we're seeing it at least among legal academics, there's a greater embrace of empiricism, and perhaps that will help us to move ahead.
Yeah, I agree with that and that commentary, and I would just add that it was sort of shocking to me when I found out about the pain studies and the studies about maternal health, that the result had been, it seemed, that the medical profession had studied the issue in a sort of scientific way and come up with interventions that were adopted in hospitals and lots of changes, and I thought, in the criminal field, when we discover problems, we just have this outcry and backlash, and a lot of it becomes accusations of moral failings. And that it seemed to be a very different approach in the medical field and maybe, I don't know if it's humility or just an assumption that, well, obviously we're perfect, so what is the problem? Because it's not us, right? So, I mean, there's just more of like, we're gonna get to the bottom of this in a scientific way. And that was our goal with the article, was to try to bring some of that way of thinking about the problem to the criminal justice field.
Yeah, and I would just add, I think, echoing what was first said, is that there is a difference between the training in the fields, and but to the extent that legal academics are able to offer empirical work that then policymakers can see, and so I can just think of two recent examples that relate to some of the examples I talked about. A professor up at UConn, now at Cornell, produced this zoning map, which was labor intensive. It's called the Zoning Atlas, and it showed how much land was zoned for single family, and that got policymakers' attention when they were like, whoa, 91% of Connecticut land is zoned for single family, meaning it's illegal to do anything else, and Connecticut lawmakers then started to think about doing things. She has explained how painstaking that work was, and she's not, like most lawyers, not trained as an empiricist, and having to get the grants and the army of researchers. And so like the support of academy to help that, because then the policymakers see that. And it took her like years to do it, but the policymakers see that, and then that has produced some of these zoning reforms we're seeing in places like Connecticut, California, Minneapolis. And there's other examples like that, but having done a tiny bit of empirical research, and Sandy's done so much more, like it is really hard as somebody who's not trained in it, and it's time consuming. So I think the support from the, our deans and admissions being like, it might take you 2 or 3 years to write this, and like you're not gonna have a product for a couple of years, but it's worth the time. Yeah.
I'd like to also go back to what Professor Zale said about the tail. So one problem we have with environmental or energy law is that we permit these facilities, and they're permitted for potentially 50 years or more. And so by the time you figure out that you're creating some really big issue, it's too late and they're there, and what do you do with them? Highways that had completely destroyed neighborhoods, the Rondo neighborhood, one of the most famous of those, that it just completely annihilated a robust area just to run a highway. Well, now they're trying to figure out how to fix that. Well, it's really tough to fix and put back together a neighborhood that's just been completely destroyed. And so what I think that what my role and what I try to do is think about it going forward. So what can we do to do reparations? What can we do to stop this from happening in the future? Some of it is about maybe we don't need permitting for 50 years. Maybe we want permitting for a shorter period of time. We start to see if this is going to create a problem, and then we can pull back on that as we go. But energy and environment is a very crazy creature that's been around and has done a lot of destruction, but the goal is that the future, this more sustainable group that's coming in is thinking about these things and thinking about how to make it better and do something better.
Thank you so much. And I think we have some members of the audience who'd like to ask some questions.
Yes, thank you so much for this conversation. My question is for Professor Thompson. I was dismayed, perhaps not surprised, but interested in the fact that the bias that we see in medicine is sort of mirrored in the law. And I just wanted to give you the opportunity to talk about the interventions that you were thinking about sharing with us. And so if you don't mind sharing more there.
Yeah, sure. So, one of the, as I said, one of the interventions that has been studied for a long time is this intergroup contact approach of getting teams working together. And that's really exciting because what the studies show is that it has the ability to change how all people in the group think, and so to improve the whole organization. But there are other approaches as well. In the laboratory context, for example, the studies show that scientists can be affected by the information they receive. So if you have someone comparing fingerprints, latent prints, do they need to know that this suspect was accused of 5 murders of children, and we really hope that there's a match here or whatever? They don't need that contextually irrelevant information, because what that information does is to bias their conclusions. So one of the things that we studied was blinding, such as is used in randomized control trials, right? So the blinding is one way to remove the information altogether from a decision maker's, from the knowledge that a decision maker has. We see that in grading in universities. We have exam numbers. In symphony orchestras, they do blinding. And blinding can be introduced in many, many places in that decision-making process. Another approach that has been tried to implement in medicine, which I guess runs counter to what a lot of medical professionals believe, is the use of standardized protocols, guidelines, questionnaires to reduce interviewer bias by trying to control the questions that are asked. And then again, you can blind the information that gets conveyed to a decision maker from those interviews by removing contextually irrelevant information. And there have actually been some research done in district attorneys' offices with blinding and with standardized protocols and guidelines to have more structured interviews and decision-making processes. So removing the amount of discretion and the kind of information that people have, as well as these intergroup contact approaches are the principal remedial interventions.
Awesome. Thank you, panelists, for just sharing your knowledge with us. I actually came forward because I was inspired partially by Professor Buck and also partially by Professor Gina, Gina is with Warren.
Gina
because,
is great.
I was in a professor's course, and you came and taught our course when I was in the Law Center. So my question has to do with admissions, but the reason I was inspired by one of your slides was because I had the experience myself. So I'm a former medical officer, and I'm also a former law student at the Law Center. And before I got to the Law Center, I went to a law school where this zoning that you showed on that screen was a part of the structure and was still in the books as I moved into that city, and I had no clue that I was moving into a city like that. And so the question I have before I bring up the small experience that I had is, what can be done now post what has happened with this law that went forward and how affirmative action is removed? What are the things that can be pulled out to be able to now highlight individuals and bring individuals into your school, but not based on race, at the same time still try to have a broad, diverse school and that you're looking for? And the experience that I had that came from that picture that you showed was I was driving through. I was a first-year law student, but because of my background, having a PhD, I was also a professor. And so I was driving through the campus, and I got pulled over. And so I was kind of shaking because I was like, I wasn't speeding, and I didn't know what was going on. And so as the officer pulled up, and he asked me, he said, "What are you doing driving here?" I took my license and told me that students can't drive on campus. And so I said, I understand, but I'm also a professor here. And he said, "You still cannot drive on campus because you have a student status." And that zoning picture that you showed, later on I found out I was living in an area that is not supposed to be an area where people who look like me live. So I bring this forward now to the question I asked before, and that is, now that medical schools and law schools have to remove race, and they have to now look at students, and they have to look at different criterion. What can be done now that that's been removed, knowing that biases exist, as Professor Thompson addressed, and knowing also that individuals will come from different backgrounds, and they may not be able to present themselves on paper as other students who don't look like them do? Thank you.
Ooh, wow. I wish I had an answer for that. I would love to hear an answer for that. I think there needs to be more time spent on assessing the entire individual and everything that they bring. And so it was mentioned earlier, it's not just about race, it's about background, it's about what your experiences were. Comparing people who went directly from law school to undergrad to law school, they're very different, and their experiences are very different than people who worked in between or did things. I grew up on a farm in Illinois. I mean, that's a very different experience than the majority of my students that I'm teaching right now, and they just think that's funny. They laugh at the way I pronounce things sometimes. And but my background is just different. But I think that we need people who are not in an echo chamber and aren't used to just seeing the same people from the same backgrounds, from the same schools, from the same everything, and just checking and presuming competency. Because as someone I think that's been historically presumed incompetent for many years, I think that you can't do that and look at the entire person. And so if we can get our admissions to really have the administrative staff have the ability to actually take a look at these and bring more robust discussions and encourage more inclusiveness from all backgrounds, that would be beneficial for everybody. And I think that it would result, frankly, if we take away some of the presumptions of intelligence, that if you went to one of the top schools or you have really high numbers, I mean, some of those presumptions are because you had parents that helped you be able to take all kinds of assessment training or helped you figure out where to go. I think that some things that are missing, and especially in the law, what I find, I was on a call with a potential employer of one of my students who was one of my teaching assistants, and he didn't do well in the bar. And, that happens. Sometimes you don't do well in the bar. But sometimes when people are coming from a first-generation scenario, they don't actually seek help either. And so they maybe didn't do well, but then they didn't reach out to anybody who could help them. I found out about it because we got a list, and I reached out to him directly, and I said, whoa, what's going on? How can I help? Ended up getting him and was talking to a potential employer for him. And she was like, well, why do you think that this happened? I said, well, because he didn't know that he was supposed to reach out, or that he could reach out, and that somebody cared, and that somebody would have his back because he felt failure. And I don't want that to ever happen. And so that's it.
I just wanted to jump in and say a couple of things. One, I'm going to say, look at the Dobbs case. Dobbs explicitly overturns Roe. Compare that to Students for Fair Admissions. It does not overturn Bakke, Grutter. So what the court has done is not said you may not consider race ever. It says it's really limited. It's really limited the ways that admissions offices may consider race. Applicants can write about their experiences as people of color or whatever dimension of diversity that they bring to a potential student body. They can do that. The other thing I have just got to say is that the majority opinion in Students for Fair Admissions sets up a straw horse about what admissions offices were supposedly doing. Oh, they were giving preferences to people of color. They were not. They were not. As a former dean, I can say with great assurance that that was not happening at my school, and I'm pretty damn sure that it wasn't happening anywhere else. Holistic admissions has been the order of the day. And in law schools and medical schools and colleges, you name it, they have developed very robust ways of examining and determining who should be on their campuses and who should comprise their classes. Because they were looking for a balance. They're looking for the most interesting array of students that they can get. I mean, and they have other outside considerations as well, like U.S. News and all that kind of stuff. But, they set up a straw horse to knock down. So maybe the next case, they'll say you can't consider race at all. But right now, let's not do that work. Let's not do that work. Let's not say you cannot consider race, because that's just not true. It's just not true. I held my tongue, but I cannot. It's just not true. And let's hold each other up. We will have to be creative. Because the other side, they recognize it's not done yet. And so what they're doing is suing everybody, corporations, employers, anybody that's looking at DEI, to try to scare them into thinking you can't consider race anymore. But it's just not true. They can. And they should. They should. We've considered, if this country put an ounce of the effort into dismantling the long tail as you described it, that they put into creating it, imagine what our society would be like. Imagine the human potential that would be unleashed. The cures for cancer that will come up. We're done. I'm done.
I'm so sorry.
I'm
For
sorry.
those of you interested in this topic, our next two panels, 3 and 4, are going to go hit right on these issues. There's a lot more to be said. And thank you so much. We'll be back in about 12 to 13 minutes. And those of you who are in the room, we have lunches outside. Please go grab one and bring it back to your seat. We'll be back with more content soon. Thank you, panelists.